Hi, this is Dan Whitney with the Whitney Law Firm in Towson, Maryland. Today we're going to talk about how a car dealer's greed in attempting to keep a $5,500 down payment that they were not allowed to keep after a car was returned led to them being forced to pay over $66,000 or 12 times the amount of what they had initially refused just to give back to cancel the deal. So this is a follow-up video to a video that had been done a couple months ago. What this arose out of is a lawsuit had been filed alleging that a car dealer had refused to return $5,500 once a transaction was canceled. Long story short, a consumer had purchased a vehicle, discovered within about 30 days that the vehicle had serious problems, and tried to cancel the loan with the finance company. He had not made his first payment. The dealer began calling him saying, we're going to repo it, we're going to repo it, we're going to repo it. My client had already had a repo on his credit history. He did not want another one. And so he ended up bringing the vehicle back, and he brought it back and he said, okay, just give me my $5,500 down payment and we can be done. And they said, no. They said, no. There is a sign on the wall that says you can't have your down payment back. All down payments are non-refundable. And for that reason, they decided to keep his down payment. So what happened was we took the case to arbitration and we proceeded with our case. We put on our case. It was a very good arbitration. And the car dealer, the owner, chose to testify as to quite a bit. And among other things, he admitted that the sign on the wall is the reason that they had decided to keep the down payment, because after all, the sign says the down payments are non-refundable, so why wouldn't they be allowed to keep it? Except for the fact that it's totally illegal and you can't do it, it's not a problem. So as I discussed a little bit in the prior video, the contract that had been signed had an integration clause, meaning that all of the terms of the contract were contained in the agreement that was signed. And unfortunately for them, the contract did not say, and the customer agrees to abide by the terms that are on a sign on the wall. So obviously, they did not win. And so what had happened is we made an argument. We made an argument for damages. And the argument went something like this. Certainly the $5,500 had to be returned. And there was a certain financial statute that the dealer had violated by keeping that and alleging that it was a fee for him not returning the vehicle. They alleged a number of things. That was kind of one of them. So we were able to get treble damages of the $5,500, which added up to $16,500. Now, during the course of the hearing, I had asked my client, how did this affect you once they kept your $5,500? And he, you know, it's always nice when somebody is testifying and all they have to do is tell the truth. It's pretty easy to prepare for. You just tell them, tell the truth, and that's all you can do. And that's exactly what happened here. And my client explained that after the dealer kept his $5,500, because remember, he has no car now and he has no $5,500 to put down on another car. So he explained that what happened was he had been commuting to a job over an hour away, but now with no car and no down payment to get another vehicle, he was unable to get another car, so he lost his job, he had to quit, and he had to get a job closer to home. That was an unpleasant experience for he and his family, and they have small children. The other issue was that now with only one car, because he was not able to buy another car for a whole year, he had to save up another down payment to get the money. And during that period of time, they only had one car. And what would happen often is, obviously that's going to create a lot of issues in a family household. But he testified that a number of times his children were left hanging at school, left waiting for their parents to pick them up because of all of these problems, logistical problems in, you know, did mom have to work? Did dad have to work? Who has the car? What's going on? And these kids were just left in the lurch with nothing to do but wait. And of course, the parents, my client and his wife, that was a point of contention. And they argued about it, and he testified that this whole experience caused him quite a bit of trouble between the job, between issues with the kids, other logistical issues. He and his wife would fight about it. and a lot of unpleasantness. So essentially, he had testified to the emotional impact, the emotional distress that he suffered as the result of the car dealer's actions. And as one of the causes of actions was a fair debt collection cause of action. And we basically said they tried to collect the debt, or they did collect the debt they had no right to collect. And in Maryland, there's a statute that allows you to recover for emotional distress under that statute, and as well under the Consumer Protection Act. And so we had argued that basically for the period of time for which he suffered, we had calculated a per diem or a per day dollar amount, and we provided a range. It added up to between. It was either at the high end we requested $40,000. We said, Your Honor, if you believe that $40,000 would be too much, we respectfully request that you would award my client $20,000 for what he had to suffer. And as it turns out, $20,000 is exactly what was awarded. So then, of course, the issue is attorney's fees, because in this particular case, as in many of them, there's no upfront charge. Of course, that all depends on the facts and the situations and the circumstances and all that, but very often there is no charge. So here, we were using the Consumer Protection Act to get the fees out of the dealer. And so we had accumulated, let's see, $29,743 of attorney's fees over the course of the case. And the thing lasted about a year from the time we filed and fought about a bunch of issues, and then we finally had the hearing. So about $29,000. And fortunately, the judge said, yes, you can have all $29,000. It was awarded. So basically what happened was, because the car dealer just refused to return the $5,500 that it had no legal right to keep, they ended up being hit with a judgment totaling $66,000. How much was it? $66,338, which is basically 12 times the $5,500 they kept. And so now a judgment has been entered against these bandits, and so what happens then is you've got to collect on it. It's not like you get a judgment and all of a sudden the money is sitting in your hand. You got to collect it. And so what has been very helpful in the past is to hire the most experienced collections attorney that I can. The client hires a collections attorney who now is going to, and is in the process of going after the dealer to get all of the money that is needed to satisfy the judgment. And what's very interesting as a side note as to collecting judgments, we had actually used the same attorney in a case where on the day of trial, the defendant in a case that was arising out of disgusting living conditions in a rental property, the owner of the property actually transferred the property to his wife during the lunch break in our trial. And then at the end of the day, we ended up getting a $90,000 verdict. And what he tried to do, in probably the most amateur way possible, was to transfer the property into somebody else's name. So it was either him or the entity could say, we don't have the property anymore. And the only problem with that is that's called a fraudulent conveyance. So this same collections attorney that we hired to collect in this matter is very experienced. And if the dealer did something silly like trying to hide their assets, I have no doubt that it will be discovered. And I just hope he's been saving his pennies, because he's going to have to turn them over to us. So I hope this has been helpful. One thing to remember is if a dealer keeps your down payment or keeps any of your money after a deal falls through, is canceled, is rescinded, the financing falls through, something goes wrong, remember, you have a lot of legal rights, and they're only allowed to keep the money if the contract says they're allowed to keep the money. And as we all know, car dealers very often just do what they want without a care in the world for what the law is, or even what the bounds of human decency are. So I hope this has been helpful. Keep this in mind. Thanks for watching. Take care.